Hi guys, Alina Shoutsova, immigration attorney from New York is here, and today we're going to have our live regarding the most recent immigration news. I'm going to talk to you a little bit about consular situation. We're going to talk about the reform, going to talk about administrative closure, which is extremely important, administrative closure in immigration courts. And of course, we're going to talk about some other important things if you choose to talk about them. So thank you very much for joining me. I see some people started joining. Say hello, hi from where you're watching. Don't forget to save your questions so we can go back to them. And I'm going to give you my answers, so at least maybe point you in the right direction. Hopefully. Hi, Sandia. Hi, George. Hopefully point you in the right direction so you will be able to find your answers to the immigration questions that are important to you. Hi, Ali. Hi, Roman. Hi, Sandia. Say where you're watching. Chicago is nice, probably very cold. Hi, Kobe. Hi, Prime. Hi, George. And of course, we're going to discuss many different things that are relevant to you as always, right? So first of all, I'm probably going to talk to you a little bit about consular practice. Why is it important? It's because, as you may be aware, consulates have been overwhelmed with COVID, with everything that's going on. And for many of you, you may be interested in this because it may be relevant for your I-601A waiver or potential I-601A waiver. Why do I say that? It's because, as you know, immigration reform may not happen, but many of you may qualify for I-601A waiver, and I know some of you were delaying it or simply could not even get an appointment, and for that reason, you're still not a green card holder. So consular practice is extremely important. And I just attended a CLE with American Immigration Lawyers Association, where actual consular officer was present and he was answering a lot of our questions. It was very, very informative session, and we received information from, first source basically as to what to do and how to handle many different issues. It's very important that your attorney also attends meetings like that, because of course when we may guess certain answers and how to handle certain situations, it's always best to receive such advice from consular officers or former consular officers themselves. So basically what he stated is something very interesting, something that I suspected all along, that consular officers are not attorneys. Hence, when they make their decisions to deny your visa, often they're wrong because they don't practice law. And that's why it's so important for you to have an experienced attorney by your side to be able to take a legal position and argue it on your behalf and find relevant sources and ears to hear you out. It's very important. Actually, recently something like this happened to my client. It happens very rarely to my clients, but something like this happened to my client. One client was accused of something that legally impossible to be accused of. He was accused of smuggling himself by a consular officer, and we were afraid that he'll have to deal with unjustifiable denial. But luckily, because we presented strong legal arguments on his behalf, the consular officer reversed the determination and issued him a visa, which is very, very important to avoid the litigation, to avoid unnecessary prolonged stay overseas. So he still was delayed in coming back home, but he was delayed by a month, about opposed to years, right? Not everybody is so lucky. According to this, attendees at the seminars, sometimes even if you are very right, a consular officer made a wrong decision, it may take you years before you get it corrected. So it's very important to be prepared well for the appointment, for a meeting with a consular officer. And of course, I know that they're overwhelmed, that they have too many cases, not enough staff. This gentleman actually who was representing the consular officers confirmed that during the Trump administration, many of the staff members resigned, and consular offices became basically without the staff to address all the issues. On top of it, the pandemic hit and everything went down the hill from there. So as a result, we are where we're at, that there are huge prolonged delays at the consular offices, at the consulates all around the world. And realistically speaking, that was information that was given to us, is that most tourist visas are going to be scheduled for 2023. All right, 2023, which is of course something that you probably do not want to hear if you are planning on inviting your parents or your family members, other family members, or your friends, right? So it's way too long to wait. But this is the reality where we're at right now with that. It's very, very important. And of course, not every case is going to be like this. Not every consulate is going to be like this. It all depends on, we're just talking about average. It all depends on specific location, on specific country, and specific situation. Requests to expedite are being processed. Now remember that Department of State announced that consular offices are going to be going to enjoy more discretion in how they handle matters. So I feel that currently there will be good opportunity to argue for those requests for expedite if you have grounds for them. So this is what I wanted to share with you about the consular practice. Also, interesting point came out as to, let's say, if an individual is from one of the countries without home, according to the Foreign Affairs Manual, what consulate to designate in I-130s or I-140s is going to be filed for such individuals? Their home country, that's where it should be, or the country where they should go for the interview now? And the answer was the country where they should go for the interview now, according to Foreign Affairs Manual. Very interesting answer. Of course, but that's something to know about, to pay attention to, so you will not be delayed in processing your visa cases once they get approved. For example, Russian individuals right now do not have a consulate. Formally, they're considered to be homeless for the purposes of issuing of the visas, and as such, when your attorney is preparing I-130 form for them, when you're going to be preparing I-130 form for your relative, you have to put Warsaw as the consulate where the visa will be issued. Very interesting point that was made by not me, but the representative or former consular officer, right? It's also true for Yemen and some other countries that do not have U.S. consul, U.S. presence. Very interesting. Now I wanted to talk to you also about a very important situation that's happening right now in the United States Supreme Court. There is an important case that will affect rights of immigrants, case regarding courts' ability to review administrative decisions. Case at hand, case that is going through the United States Supreme Court review right now, has a situation involving adjustment of status issue and claim of U.S. citizenship. But what came out of this case is that the government says basically that an individual does not have a right to have adjustment of status decision reviewed by the courts because it's based on discretion. But it seems that the United States Supreme Court, it seems right now, according to the media resources and those experts that follow U.S. Supreme Court decisions, they say that the court is likely to say that there will be some review of the administrative decisions. It's extremely important for those who have something like adjustment of status denied. When, for example, you argue that there is a difference between how you view facts of the case and how the government views facts of the case. For example, if you're saying that what you committed does not amount to claim of U.S. citizenship, and they say it does, and it affects your eligibility for the green card in the United States, perhaps after the summer we will have a clear answer as to whether or not you'll be able to sue the government in this situation and actually have a chance at court reviewing your case opposed to USCIS. Extremely important. You may be familiar with the situations if you went through this tedious process of suing or immigration benefits. In certain situations, you can file petition for review, for example, if you were ordered removed. And not often, but you have a chance of receiving a status, while somebody who files for adjustment of status, for example, does not have such a chance. So it's a huge difference in rights of the immigrants. It's a very important decision. They said that our oral arguments just happened and the decision is expected to come out about 6 months later. Very, very important. And now, of course, we're going to talk about your favorite topic, immigration reform and parole. What do we know about that? What news do we have? Zero. What we know about that is that Charles Schumer, again, on Monday or today, stated that he plans that the Senate is going to be voting on BBB bill by Christmas. They have a very ambitious deadline, considering that the budget was extended, if I'm not mistaken, by February. So I have sort of bad news. I think that they may delay everything by the same deadline, February. But we do not know. We'll see what's going to happen by Christmas. Of course, they still have to negotiate with certain senators who have concerns about the bill, about the language, about the Senate parliamentarian. They did meet with the Senate parliamentarian already, and she didn't reject the proposal, so it may be a good sign, but also we do not know what exactly it means. It's just some bits and pieces of information. I wouldn't, strictly speaking, rely on that. Unfortunately, there are more delays in this situation. And again, if you believe you will qualify for something else, be prepared to qualify for that just in case, right? Just in case. But now we have timeline by Christmas. And I see some of you guys, you submitted some questions to the chat about this. And of course, I'm going to answer those questions as well. Finally, important point. It's going to be easier to receive administrative closure, or at least it should be easier to receive administrative closure in courts. Very important. Memo came out in November stating that if the government does not object, generally speaking, immigration judge should grant administrative closure. Extremely important, because let's face it, many people don't have really strong cases for asylum. I met so many cases where people filed for asylum 5 years, 6 years ago, because they met somebody who said that, this is a way for a green card. And the person eventually ended up in removal proceedings because, of course, they filed the asylum case years after their deadline, and now they're kind of stuck in this process and they're scared. And at the same time, they have strong family ties in the United States, or community ties, or business ties. And this administrative closure is vital for them, because if you're planning on, realistically speaking, if you're counting on immigration reform, you need this time in the United States not to be deported in the meantime. So this memo is extremely, extremely helpful. Of course, if the government does not object. Why would the government object? Well, they would object probably if there is some very adverse information in your file. Let's say maybe fraud, indication of fraud. If maybe there are some heavy criminal convictions and no evidence of rehabilitation, right? Perhaps there is just some other negative history of filing and refiling of different applications with no really real ground of being ever granted. But in most cases, I think that you should be successful if you do a good job arguing your position. So now I hope you find this information helpful, by the way, because I think it's very important. Now let me go to some of your questions and let's see what we have. Hi, George. Any chance that the parole cut-off date can be brought back to a more recent date? I really do not know. Judging by the way that this issue is being discussed by the opposing side and everything else, I doubt that. I'll be very careful to be optimistic here, just because, as you see, for them to be able to, for Democrats, to be able to pass anything, they have to be more conservative. And for that reason, I don't think that the deadline is going to be removed. But of course, I'm guessing here just like anybody else, right? Watching from Florida, Tia. That's nice. It should be warm there. Hello, do you provide service for taxes with international students, OPT? We do not provide any taxation advice. Nope. Yes, it is very cold today. Yes, Ali. I know it's becoming very cold in New York too. I guess this is the season. But I've never been in Chicago in winter. I think it should be pretty though, right? Should I file? Hi, Tia. Should I file for my daughter U visa or should wait for parole? Sweetie, if you have a chance for a U visa, file for it. Do not wait. Okay? This is my best advice, even though you're not my client and no attorney client relationship is created here. But this is the rule of thumb. If you have an opportunity, even if it's a slight, for something like a U visa, absent any fraud or anything like this, file for it. It's important to secure your place in a line. Your visas currently are pending for a very long time. Also, if you pass the bona fide determination, you'll be able to get an employment authorization. And currently, people who are filing for the U visa are being protected by the government, not going to be deported. Extremely important. U visa is an excellent opportunity, if you can call it this way, of course, because if you can call it this way, just because, you know, victim of a crime, it's already a misfortune. But it's an excellent opportunity from a legal point of view to receive status for somebody who has a prior order of removal or sometimes subject to some other very heavy or difficult to deal with grounds of inadmissibility, just because it allows you to file for a very generous waiver that other reliefs do not allow for. Hi, Ali. I want to know, do you think Plan C is a change cutoff date update about essential workers immigration? Yes, same question, guys. I don't think they will change the cutoff date, I'll be honest. Update about essential workers, that's a good one. I think that there was a lot of advocacy going on to for the senators to include essential workers in the bill. And I hope they will listen to that just because I think it's very important and deserving, right? So I do not know. I think we have little hope for that just because it's been rejected already once by the Senate parliamentarian. But I would just have this hope in me because I still hope that they will do the right thing by you guys. Is parole a major change in law since this was the reason for the Senate parliamentarian to drop on Plan A and Plan B? It's not even about the major change in law because what is a major change? We can't really say what change is major or not. It's a very relative term. But what she was saying is that the impact of that is going to be on the immigration community higher than the impact for the budget, right? But it's very relative terms because, how can you measure impact of family being able to stay together versus $20,000, right? Of course, you're going to say that family gets a bigger benefit than economy gets $20,000. So it's more a position that I think she's taking, saying that, oh, this is not the proper way to handle that. That so many people will be affected. They also take into consideration amount of people that are going to be affected. That's why I see those numbers, 7 million, 5 million, 10 million. Shh, don't say that. First of all, we do not know how many million. Honestly, if you recall, when the DACA was being passed, they also estimated millions and millions of people. And guess what? Several 100,000 filed for it. Okay. So there is a huge estimate, but the actual numbers are going to be much lower. And it's important to remember that, especially when you're arguing about something as important as this relief, because the Senate parliamentarian seems to be paying a lot of attention as to how many people are going to be affected by this and what their benefit is going to be compared to the budget benefit. And I'm going to tell you that their benefit, of course, from their point of view, is always going to be higher than any budget benefit, understandably, because we're talking about person's lives in the United States and ability to eventually, somehow legalize. What's important here is that parole, unlike other proposals, is a temporary measure. And I think this should be heavily emphasized by the Democrats, that it's a temporary measure, even though it may lead to something in the future. But unlike registry or plan A that would lead directly to the green card, it does not do that, right? So that may be in their favor to show that, listen, initial impact may be high, but what really is it? It's just a work permit. All right, any chance about Essential Workers Act? Yeah, I think I answered that. I don't think there will be a lot of chances at this time. Okay, there may be chance, because remember, this what we're talking about right now is reconciliation. It's just it's easier to pass opposed to regular law, right? It doesn't mean that the doors to other acts and proposals like U.S. Citizenship Act 2021 that the Biden administration proposed at the very beginning will be completely foreclosed. That's not what it means. It's just that we want to have a quick something that's going to be passed now. Hi, Harsh. What about essential workers? The same thing, essentially. Hi, Milad. Hi, Andromeda. What about people who already have administrative closure and have their working permit being renewed every 2 years? Are they going to have travel documents? Guys, if you have an administrative closure, it means you are in removal proceedings. A person in removal proceedings cannot get a travel document. You renew your work permit. Why? Because technically your underlying asylum application is still pending. That's why you're renewing your work permit. So it's not a work permit based on something else. It's just technically you're still in immigration court, but proceedings are not active. They're dormant. That's all what it is. And generally speaking, people like that do not have an opportunity to file for travel permit unless the law is going to change that. So there are a lot of questions we do not know answers to. For example, will parole have effect of being inspected and admitted for 245A adjustment of status purposes? Will this parole be considered admission in any status or not? Will this parole, have other legal consequences? I do not know, because there are different paroles in immigration laws in the United States, and they treat differently for different purposes. I guess we're going to have answers if it passes later. Hi, Kaliwitz. Hi, if they pass parole with reconciliation, will I be able to adjust my status within the United States rather than filing a 61 waiver? Do not know. Just was talking about this. I do not know. Why? Because I do not know. Will it be considered as if you were paroled for adjustment of status purposes? I guess we're going to see that, right? Will you still need to travel on advance parole and come back? I do not know. I hope yes, but I'll be conservative and would withhold my final answer until I actually see the regulations and can say yes or no. How long does an appeal for I-130 take? Guys, recently I'm going to tell you exactly 2 years. That's the 2 years. The appeal was pending for 2 years. But your situation may be different. Maybe it was pending for that long because of the COVID situation, and now it's going to speed up, but I will not be able to tell you for sure. I can just tell you approximately. Hi, George. Any chance that DACA will reopen again anytime soon? It may be because of this new regulation that they're passing. So it may be the case that new applications for DACA will be accepted. Maybe. Hi, Nander John. If your visa application has been approved for deferred action, can I apply for advanced parole for travel outside US? How will this affect my case in the future? Deferred action means that you didn't have the final determination yet. I would suggest that you speak with your attorney about this, okay? Because that's very important, that they consult you and a person who knows of your situation better and will be able to advise you way better as to where you're going, why you're going, and so on and so forth. Usually, I would say it's a no, but as I said, you should consult with your lawyer. Hi, Tia. Can we talk for you to file EU visa? Sure, guys, if any of you would like to have a confidential consultation, please call my office, 917-885-2261, and my very capable assistants are going to go walk you through the process of making an appointment, what you need to do, what you need to prepare for it, the dates, the times. Absolutely, I'll be happy to review your situation and give you my best opinion as to what I think should be done, how long it's going to take, and so on and so forth. Hi, Anna. Hi, Alina. Can my husband, who is a green card holder, petition for me if I overstayed and I don't want to leave the country? If you overstayed your visa, Anna, and you do not want to leave the country, your husband may just start the process for you, but you will not be able to adjust. So can he petition? Yes, he can file the initial petition for you, alien relative petition, but if you overstayed your visa, under 245A requirement of INA Act, you will not be able to adjust your status. I think 245C is going to prevent you from doing that. The requirement states that you must maintain, you must show that you have maintained your lawful non-immigrant status since the time of your entry. So you will need a waiver and leave the United States also. However, you may fall under certain exceptions. For example, 245I exception for grandfathering provision, or perhaps you just need to wait for your husband to become a U.S. citizen, and then you'll be able to adjust. Because for immediate relatives of the United States citizens, this waiver comes automatically, waiver of unlawful presence. Hi, Dwight. I have an aggravated felony. They say it was a first-degree burglary. The case was with me and my girlfriend, domestic case, but they gave me 10-year bar. My 10 years up. All right. So if you have issues or challenges related to criminal convictions and deportations, if you were deported, you need to collect your full criminal file and your full immigration file to see if you're still inadmissible. What happens is that sometimes a person may still be inadmissible, for example, or deportable, even though so many years passed. Why? Because the same event may make you inadmissible on various grounds. For example, a conviction may make you inadmissible. Convictions that led to deportation. Deportation makes you inadmissible if you're physically deported outside of the United States for, let's say, 10 years. Plus, the conviction may still make you being deportable if there is no waiver available to you. Maybe a waiver is available, right? So you need to see what exactly happened from legal point of view. And of course, during this quick, assessment, I cannot tell you because it's far too important to important of issue. So I would say that you collect your records, immigration files, criminal, and what you're looking for criminal, you're looking for this. You're looking for certificate of disposition and minutes of the guilty plea. Very important, right? And then you consult with immigration lawyer to see how you can fix the situation. Very important. Hi, ticket view. I came USA more than 3 years ago and I'm undocumented. And it's already overstay. My mother is a green card holder. Can I do adjustment of status or can I get any benefits if BBB pass? If you are married, your mom can file for you your petition for you. She may file petition for you. What would be your chances of receiving an immigrant visa overseas? Because you will not most likely be able to adjust your status. Somebody who does not have legal entry, unless again he qualifies or she qualifies for an exception, would not be able to adjust their status in the United States. And if you're in a preference family category, meaning you're not an immediate relative of a U.S. citizen, you have to show that you maintain your lawful non-immigrant status throughout the time of your stay in the United States. And of course, you will not be able to do that. Means that you may have a chance of I-601A waiver, but not adjustment of status. I-601A waiver may be applied by those who have an immigrant visa petition approved for them, and they have a spouse or parent, you have the parent, US citizen or lawful green card holder, who will experience extreme hardship in case of your removal, for example, or if you're in a or they cannot, or they can show that they cannot come with you to your home country. Now, your mom is just a green card holder. It means she will be able to start the process for you only if you are not married. Very important. There is no category for sons or daughters of married sons or daughters of green card holders. Hi Rico, hello. My I-45 got denied and then I got biometrics appointment. I was today at the biometrics. Now my status online changes to cases being actively reviewed by USCIS. Did you file a motion to reopen? Maybe. And what was the reason for the denial? Did you ask for the case to be reopened or something? Maybe your lawyer did. Perhaps, I would not know what to say, unfortunately, without knowing more. Hi, Marina. Hi, Alina. I have appealed for removal because my case was denied almost 3 years ago. Can I get the parole if it passes? I would say that you should be able to, right? Because parole is not something, parole is not a green card. But when it passes, we will know qualifications for it better. And then, of course, your lawyer will be able to advise you exactly what's going to happen. Parole, I think if it passes, it's going to be more like a deferred action, basically stopping your removal for a while, if you otherwise qualify for it. That's what I think is going to happen. Hi, Danny. How complicated is it to change from B1, B2 to F1 status studying in the United States? Excellent question, Danny. It depends on when you're filing your application to change your status, how strong your evidence is. Can you demonstrate that your F1 is going to be done for your benefit, full-time study, school, that you have funds to support yourself here and pay for tuition, and also, of course, that upon completion of your studies, you're going back home, that you are truly a non-immigrant. And if you have all this evidence, you should be successful, right? And you also have to know that your application to change your status must be submitted before the expiration of your current B1, B2. So you probably would like to first check your I-94 online record and see what's actually in the system for you, to make sure that you're still in valid non-immigrant status. Very, very important. Well, guys, thank you very much for watching, joining, and thank you for your questions. Again, my name is Alina Shaltsova. I'm an immigration lawyer. I help immigrants in all 50 states, and those who have U.S. immigration questions and challenges overseas, you can visit my website, www.shaltsova.com, my last name.com. I have a lot of useful information and answers to many common questions related to asylum, removal, how to prepare for removal proceedings, for example. Asylum, we just started a new section, country conditions. We're going to be publishing like little summaries of essential country conditions related to specific questions in countries all over the world. So you can start your research. For example, we started doing it on Russia, and of course we're going to address it for the other. I'm going to publish other materials as well. Other questions we have also about citizenship and a lot about motions to reopen and appeal. So I think it's a good place to start your research. Of course, for consultations, you always should have private consultations that are confidential, where an attorney can have an opportunity to ask you relevant questions and review your files. Very, very important, because sometimes you forget what happened, or sometimes your files have truly damaging information that you were not aware of, which is very, very important for you to know and to be able to prepare you. So again, thank you for watching. Please like, share this video, subscribe to my channel if you have not done so. I'll be happy to see you in the future during my lives and my future videos.